Okay, so patents. We'll start with patents are go back to the Constitution, which grants Congress the power to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. Doesn't mean that Congress has to have patents, but it does mean Congress has the power to, create the patent office, and the patent office has been around since the beginning of the country. And as Sean mentioned, there are 4 statutory categories, which we'll go over a little bit more detail as we go: process, machine, article of manufacture, and composition of matter. Here, most of them should be fairly clear. Processes have been a little bit different than the other categories, and I'll get to that when I get to eligibility a little bit later on. But for your purposes, it's worth knowing that if it's a machine, you can get a patent on it, assuming it meets the other requirements. Same is true for article of manufacture, and same is true for composition of matter. And if it's a process, it might be eligible, but it's not that simple. So, patentable subject matter. According to the statute and initial interpretations of the statute, anything under the sun made by man. Though, as again we'll get to in a little bit, that's not quite true, and the Supreme Court has put limitations on certain categories that, in particular, software-based processes and medical diagnostics. So if you're in either of those areas, it's a more complicated question than it would be for most other areas. Other things, as Sean said, a patent has to be useful. Now, well, Sean gave some examples of useful and utility. Really doesn't actually mean that much. Almost anything will meet the usefulness requirement if it has some, there's some reason a person might want to buy it or do something with it. If it's just designed to be thrown out and doesn't have any particular way, there's nothing you can do with it, there's no use, doesn't build, doesn't make a noise, it doesn't do anything, even if it's silly, then it may not make it. But in terms of filing an application, you don't have to worry too much about usefulness as a requirement. And if it really wouldn't meet the requirement, its odds are no one would ever buy it from you. So there's real questions as to why it'd be worth trying to protect. The second requirement is something has to be novel, and this is a lot more important. Patents with applications, and then when they get issued, have several components. You'll have your specification, which lays out what you invented, often what area it is, why it has some value, what the background is, what else has been done in that area, and then what you did that's different. And then its patent must end with claims. This is true for actual patent applications. You can file a provisional application without the claims, which is useful as a placeholder to protect your invention as you work towards filing the claims, and buys you a year. But for a patent application, a utility patent application, you have to have claims, and the claims have to be novel. Now, what does novel mean? Novel means new, that no one else has done exactly what you claimed. Each claim is made up of several limitations. Doesn't mean that each limitation has to be new. You can combine things other people have done, and in fact, most inventions will be combinations of things that other people have done. But the claim as combined has to be entirely new. So if you think about, let's say all that existed was a stool, and then someone invented a chair. So a stool might claim a seat with, attached to 3 legs or 4 legs. That might be the claim for a stool. Now, if you have the first chair ever invented, you would add a seat attached to a back. The seat is also attached to the 3 legs. And the new part, which would make the claim novel if it was the first one ever, was the adding the back onto the legs and the seat. So to figure out something that's novel, you have to look at what all the other patents are, and the other written materials, anything that's been sold, and see, do you have something, at least one part, one limitation of every claim. You can have many claims in a patent where you added something new. Then the next requirement is it has to be non-obvious. What does that mean? Well, if you take, a minor change, just combine two things which everyone knows this should be combined, and which makes perfect sense, and anyone who's trying to solve the problem would solve in that way, it's likely obvious. But if you combine something in a new way, or in a way that's not likely to be done by others, that has never been done, or if there's some reason why people wouldn't want to combine it that way, then it may be non-obvious. So after we get to through non-obviousness, the next one is enablement and written description. What does that mean? So patents are not written for the general public. They're written for other people in the same area. So if you're patenting a particular type of machines, other people who work in that field, same thing as if it's a patent on a new molecule, it would be chemists. If it's a new drug, it would be someone in the pharmaceutical industry, and they have to be able to read and understand what you wrote. So written description means that you actually describe what it is you invent, and enablement means that someone of ordinary skill in the art, which is a technical term, but it means someone who fits the requirements for that area of invention, could make what based on reading your specification, your claims, could actually build what you claimed with a reasonable amount of experimentation. So it doesn't mean they have to be able to do it in a minute or in a day, but if someone were in your area were to read the patent, and it would take them 10 years to build it, you're probably not enabled. And then where the cutoff is depends a little bit on the area and the level of skill, but figure if it's months of experimentation, you're probably not going to be enabled. And if it's days to weeks, you probably are. Okay, so the US used to be a first to invent system, unlike the rest of the world, which has always been first to file, which means if you invented and someone else filed an application first, but you could prove that you had started the process earlier, you could still get the patent. That's not really true anymore. There's now a strong reason to go and file earlier rather than later, because you can't swear behind things the way you used to be able to. There also are bars that you should be aware of as you're thinking about your products and your inventions and whether you want to file an application. Quickly, if you publish something which explains how your patent works, it's an article, you show it in public, use it in public for demonstrations, or you sell it, that sets a bar. You have a year generally from any of those events to file your application. Otherwise, it just goes to the public. And the point of that is, patents exist to get people to disclose their invention and share how they do it, and then you get certain rights. But if you've already been using it and then you take it away from the public later, that wouldn't fit the requirements, and that's why you have limited time from when you start to show things. Now, there are exemptions if you're using it in public for the purpose of testing it out, but you really have to be testing it. You can't be selling it. You can't be just running it for months or years without having some changes. But if you're modifying it and you're not quite sure what the invention is, then you have likely extra time. As I mentioned earlier, one way to basically hold your rights is to file a provisional application. There you have to include the specification that you would include, but you don't have to have the claims yet. And that gives you basically a hold for a year where you can then file the rest of the full utility application and keep your spot. So if someone else in that year files an application or publishes something or starts selling something, you're still likely to be okay. Okay, assignment and shop rights. If you have people who are working for you who are building something, you likely want to have a contract with them which says they assign any rights to potential patents to you so that you don't have to worry about ownership rights later, or at least you want to think about this and make a decision early on, because they can save a lot of trouble. But if you didn't have an assignment and you didn't have it in the contract, and for some reason you can't add it in now, you do have a little bit of a safety net, which is called, relates to shop rights. That is, if someone is working for you and is part of their regular job, not on the side, but part of the regular job using your equipment, they invent something, then you have certain rights to it. Not rights over their rights, that they will still likely have the patent, but you can make or use it based under certain conditions. Don't have time to get into too many details on federal funding and the tech transfer system, but it's worth knowing that that even if the government were to provide grants, which ultimately lead to a patent intervention, you can still get a patent. You still own it, and the government will have potentially certain rights, but it depends on, were government inventors involved in the invention? Was it just funding? How much funding? How much did you do after? Suffice to say, it's a very complicated and detailed process, and as with many things here, if you have further questions on it, it's great to talk to an attorney. We'll get to a little bit later how you can do that. So patent term used to be 17 years from issuance. Now it's 20 years from filing, with some extensions depending on how long the patent office takes. So if you file and it takes 10 years to go through prosecution, there's lots of back and forth with the patent office, you can get an extension on it, but in general it's 20 years. So that's the time you'll have to, where you have some rights over your invention, where you can make your money back from it. Transfer of rights. So there's two things besides selling things, which you can do with or without a patent. If you have a patent, you can assign it to someone else, or you can license. So assigning basically means giving them all your rights. So maybe you have a great invention, or you don't want to produce it yourself, you don't have the resources, you want to sell it to a big company, or sell it as part of some other company. That's where these time would come in. Or you can license it. And so licensing, if you have something that's going to be used by many companies, you can have an exclusive license just to one, or you can have many. And if you have a product, which let's say is a good component for a lot of companies to buy, and you think maybe people may want to make your product, you can then license it out, and that's a way to generate revenue from the patent. Okay, so when do you want to consider filing a patent application, or at least talking to an attorney about it? So you have to disclose your invention for some reason. If you have to disclose it, then trade secrets, as Sean mentioned, won't work. And once you disclose it, you're going to be setting the deadline as to when you can file. So that's a strong point to think about. Okay, is this something which I would make sense to protect? And you have the resources to do so. Another question is how easy is to reverse engineer, which relates to disclosure. If someone can buy your product or look at your code and figure out what you did and how you did it, then a trade secret is not going to help you. And if you want to protect it, you'll basically need to have a patent. If something is very hard to figure out, then a trade secret could be helpful, and you may not need to file an application. Other reasons, so looking for outside investment. As Sean mentioned, as we get to a little bit later, often, though not always, angel investors and venture capitalists will look at patents as one of the major resources from a company. And if you're looking to try to raise revenue, show that you have some, own some part of the market, show that you have patents, at least applications on file, can be very helpful there.
We're talking about when to consider patents. So we mentioned outside investment. So we're interested in licensing. If you have the invention which you don't want to produce yourself for whatever reasons, but you'd like to license it out because you think other companies would be interested in producing it or including it as part of their larger products, then you can certainly do so without a patent, but it's a lot easier if you have a patent, so you can go to them and explain why they actually have to make a deal with you, and you have you would include the license as part of the contract. Now, additionally, there may be some trade secret parts of that component, which we can get to in a couple of minutes. But again, the patent is a strong, factor in whether or not you can actually license out your products. Another thing to consider is there significant value in your product in one or a few inventions? You think about, some inventions, the entire thing can be covered in one patent, while other things might be a very small component as part of a cell phone. So, example, cell phones today, cars are this way too, may have thousands or tens of thousands or hundreds of thousands of patents that cover all the things. And each little one may have value, and it might be worth it if you have an invention in that area to file and pay for an attorney and pay for filing fees and take the time for it. But if it's a small, relatively minor addition, you may not be able to recoup the cost, and it may be something at least to consider. Can you get enough value from it over the life of the patent that it makes sense to go forward? And this is something which you can, any good prosecuting attorney can help you think about that. Okay. So I mentioned way back a while ago that while anything under the sun made by man is theoretically eligible, that's not exactly true anymore. And that's because the Supreme Court has had a number of cases where they've heavily limited, or at least potentially heavily limited, computer-based inventions and medical diagnostics. So if in the exemptions we're talking about here are abstract ideas, generally in computer inventions. So if you have something and say, do it on the computer, but it's already been done either by hand or by some other thing, that's not enough. You have to, at a minimum, in their claims, show why your invention is making the computer do something better than it could do before. And it's not just faster. It's adding some kind of new functionality, or doing something in a way that could not be done elsewhere. And the law for this area is still relatively muddy. So it can be hard, even if you talk to a good attorney, to be positive if you can get a claim. You could probably get something issued, but whether it will hold up in court is difficult at this point because the law is changing. There are many court cases that say what's not eligible from the Supreme Court and from the federal circuit and from district courts. And there are a few court cases on what might be eligible, but they haven't set a direct rule saying, well, if you do this, it's clearly enough, and if you don't do this, it's not enough. So for software-based claims, a lot of thought has to be involved. Same thing true for medical diagnostics. If it's a law of nature, if you just figure out that certain markers tell you something, it's probably just claiming test for the marker and then tell the person what you found likely isn't enough. If you have a new way of testing or some whole new process, that may be enough. But just figuring out that some biological marker is really important, even if it's vital to health, isn't really enough at this point. Okay, so obtaining a patent. So if after all of this and thinking about everything I've discussed, what do you do if you think you have a patentable invention? So I will say you can file a patent application yourself. You don't have to be an attorney to do this. You're filing on behalf of yourself. But given the time and the complexity and the costs, I highly recommend that you speak with an attorney. Somebody you can find. There's plenty of attorneys you can pay for, or if you don't have the resources to pay, you do have a couple of options. So Sean had mentioned our clinics, and he's going to get into a bit more detail on the innovation clinic. Might turn it back to him in a couple of minutes, but the innovation clinic is certainly one option. And there we do have prosecutors who work with us who can help you to file an application if you meet certain requirements. And beyond what we can do, because we're a great center, but don't have a ton of staff, the USPTO, which I've got a link there, has a patent pro bono program with practitioners around the country, where if you follow certain requirements in terms of making sure you understand a certain amount about patents and go through some basic things and then file a provisional application, and you show you meet the funding requirements, which relates to the federal poverty level, they can provide you with a pro bono attorney who can help you file the application, which is a great option if you don't have the resources to do it yourself. So I'll talk a little bit about patent enforcement. So what can you do if you have a patent? The patent lets you control, at least to some extent, whoever makes, uses, or sells a patent invention. Some people think a patent's the right to make it, but there's no direct right to make it. Anyone can make, well, it's a right to stop someone else from doing something. Though because of Supreme Court cases, it's really, in most cases, more of a right to charge someone if they're doing something than necessarily to stop them. Though it is still possible to get an injunction to stop someone under certain circumstances. So what do you do if someone is selling something which you think is infringing your patent? And infringing the patent means practicing at least all the limitations of at least one of the claims of the patent. So you have a couple of options. You could send them a letter, tell them you have a patent, that you think they're infringing, why they think they're infringing, and ask them to either stop or to pay a license. This is good because it puts them on notice, which means that if they continue to infringe after this, you might be able to get enhanced damages. Generally for patent litigation, unlike copyright, there's no set numbers. You can get a reasonable royalty, which is what you would have been able to get if you had reached agreement for licensing beforehand, or lost profits. If you can show that you weren't able to sell so many of your products and you would have made a certain amount on each one sold, you can possibly get lost profits, and that's it. But if they knew about the patent, either because you have the patent number on your product, or you've told them, particularly if you told them about it, and they infringed anyway, after knowing that the patent exists and that they likely infringe, you can get enhanced damage, which can up to triple the either reasonable royalty or the lost profits, which can be a pretty big number depending on what the area is. The downside of sending the letter is you've now told them that you are likely to sue, and if they feel that you're likely to sue and they don't want to license, they could then file a countersuit first and choose where to sue to try to invalidate your patent. They also, even if they don't want to file suit in district court, have the option of filing something at the patent office where they can challenge your patent. It's called an inter partes review, and they can challenge is slightly limited compared to a district court. They can show through other prior art or publications that someone had invented it first, or that your patent was obvious, and that is, while still relatively expensive, much cheaper than district court. IPRs usually cost $100,000 to maybe $300,000 to go through, while district court litigation for a patent is often on the realm of a couple of $1 million. Depends a little bit, but those are general numbers. Now, if you are afraid of them responding that way, and you're going to sue because you think they're not going to license, it's not their style, or they might be willing to license, but they're a competitor, and you have some reasons why you don't want them to be in your area, and you really think you can get an injunction and stop them, then your option is to file a lawsuit before you file the letter, which, as I said, lawsuits can be very expensive. But there are reasons why it makes sense to file first, and this is another one where it really does help to figure out your case for doing what you're doing, and talk to an attorney and figure out what your odds are of winning, and do you have the resources to make it through the whole case, and what would you be willing to settle, and where all the numbers come in. Most patent litigation settles, so even if you really are set on stopping them, there's still a pretty good chance you'll end up reaching agreement at some point. It tends to be just a numbers game. How much are you willing to, if they pay you a certain amount, what's the amount where that paying you would be enough for you to let them continue, using your invention? And knowing that in advance can certainly help with how the trial proceeds.